June the 14th, 2017. First order of business is to adopt the agenda.
So moved.
Second.
And seconded. All in favor?
Aye.
We want to review and approve the minutes. I received mine in the email and looked them over. I don't have any changes or corrections.
I'd make a motion to approve.
Second.
Motion's made to and seconded to approve the minutes for the last meeting. Director's report.
Yes, sir. Thank you, Chairman. We'll just do the last month since we do it month by month now, and then we'll cover the end of the year. The total revenues for April was $32,090. The total expenditures was $21,000, leaving us a net surplus of $11,036. Besides the anomaly that we discussed in our last meeting for February, we're tracking in the right direction. So that leaves us for a year total expenditures of $284,955 and revenues, and then expenditures of $158, with a net surplus for the fiscal year of $126,269. Was there any questions on that or any follow up?
When does the state withdraw their stipend or their part from us?
Are you referring to the cost to print the licenses themselves, those costs, or?
No, we have every year we turn over our excess money to the state, and I'm not sure where it goes.
So it doesn't necessarily turn over. The state would have the right to take those funds if they needed to, and you would be informed. So otherwise, they continue carryover. That is correct. That is correct. In the event that you have some, like when we invested in our technology and had a larger amount charged, it can draw from those from the previous year's amount when it's something big. So it wouldn't necessarily be taken. Okay.
Do you notice a trend? So that since the applications are every 3 years now, we have a
It hasn't. We've seen a decrease because not everyone is, applying for licensure like they used to, just due to changes in the statute. But I think we're still at a good place so far with our finance.
And they're pretty consistent too. They did provide that historical trend at the bottom there in our licensing and case revenue, where it shows fiscal year 2015 and if you see the figures are pretty consistent.
questions. Entertain a motion to accept the director's report.
So moved.
Second.
Moved and seconded. We accept the director's report. All in favor say aye.
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 Aye. Legal report. Let's take just a moment. Okay, are there any questions, corrections, comments about the legal report? Steve? Let's take them one by,
Record,
let's take them one by one, and no, let's go to
the ones we have questions about, and then read them all in the
the
record.
ones you have, that you have questions about, if we have questions.
Being deferred to the next board meeting, need information from the respondent.
Actually, sir, I did get more information from the respondent between the finalizing of this legal report and today, so I can provide an update. Okay, so this was number 11, I believe. The respondent did provide a response to us, and they stated that the account was closed. It appears we did not receive the response for whatever reason, but as of March 13th, 2017, this was removed from the consumer's credit report, and they have again submitted all the necessary forms to make sure that it's been deleted from this consumer's credit bureau report. They also had a CFPB complaint, which they also responded to and was closed. So my recommendation is to close this matter.
See the CFPB report they responded to, did they provide that to us in their,
No, sir.
told us they had one?
The consumer, the complainant, told us that that was also filed in conjunction with the one that was filed here.
Were they timely in their response? Did they get back to us? Because you gave them notice of the problem and,
Yes, sir, they were.
oh, okay, great.
So they timely responded after the second request.
They timely responded actually when they were sent this complaint by our office.
Get it?
Yeah, I'm not sure exactly why. We just do not have it. We have the green card that they received the complaint, and they did in fact respond because they provided me with that information as well.
Other one, Steve?
Well, when we read that one, because the recommendation, you'll have to read the new recommendation in, I guess, when you read that one in.
Yes, when we approve it,
Approve it,
when
okay.
we approve the legal report, we'll read that recommendation.
On number 12, did they ever provide us the CFPB response that they provided? I mean, are we just taking their word for it that they did clear up the response to the CFPB?
We do not have the CFPB response or the actual complaint or any of that information.
Something you ask for? If they tell you they've had a complaint and they've responded to the CFPB, do you get a copy of what?
Usually they provide the response to us directly to the complaint, so we do not ask for the CFPB response.
The used car lot guys. The bank hasn't gotten back to us.
No, and I have reached out to them again, and I am not getting any response, and this case has been pending for quite some time.
I don't know if we have the jurisdiction to do what ran through my mind, but I think we should censure the bank or send the bank a warning or send it to the banking. Do we know that they are actually placing with this car lot accounts that the car lot didn't sell?
No,
It says that in here, that that's what they're doing.
right, but we do not know that that's what in fact is happening. That, I think that was the point to clarify with them, what exactly is going on here.
How did we understand that complainant alleges used, and not all the accounts assigned? How does the complainant know that not all the accounts are assigned? Did the complainant buy a vehicle from this company, or was theirs one of the ones that they didn't buy a car from them, and this car lot calls them? How do they know that the bank sends?
This is just the allegation made by the complainant. We have nothing that corroborates that.
Have we reached out to the bank at all to see?
Yes, that's the main problem. We're not getting a response from them. I have been transferred and referred to several people and just leaving voicemails, and they are not responding to this.
What's our authority?
I mean,
None with the bank?
I don't see how we can,
Unless the bank has hired them as an agent to do collection, and they're an agent for the bank, whether they're operating under the bank's name because it's the bank's paper. I think we've got a way we can touch the bank, but we don't know that the complainant didn't buy their car there. So if the complainant bought their car from this lot and the paper was turned back to the lot, I don't have a problem with the lot following up on the paper.
Actually, this complainant didn't even purchase the car. They just are making this allegation, meaning they have reason to believe that this is what's going on.
Did they get a dunning notice from the car lot?
No, they are in the repossession business, the person who has filed this complaint.
Okay, that just got odd.
Yeah.
Really did.
I mean, what's his basis for complaining? Just being a good citizen, he doesn't like the car lot, so he's going to mess with them?
I'm not sure, but I believe he's just trying to be a good citizen.
Oh. Well, if it's not a debtor who was actually dunned,
It is not.
Then I would suggest that we don't play this guy's game and try to mess with somebody he doesn't like, if he's a repo guy.
Yeah, I have no information about his interaction with this particular.
There's
lot,
no debtor involved who was dunned by a company for a debt that may not be licensed.
No, sir.
Okie dokie.
Our statute does provide that it's against our statute to hire an agency that is not licensed. If somebody does that, and that's what I thought, that the bank had hired somebody to do collection work, then that would be our avenue to the bank. We could find the bank for hiring.
But if the repo guy wasn't done for collection or wasn't collected upon and he's complaining, that just sounds malicious to me.
I believe he felt that there was unlicensed activity going on and had a duty to report that to the board. But there's no substantiation or...
I'm just curious, where's his duty? He's not licensed as a repo guy, is he?
That I don't know. But as a consumer,
I'm glad he's
felt,
doing that as a consumer, if that's in fact the case. But where's his standing? Where's his duty?
Just his internal duty. He felt that he needed to let us know that there was unlicensed activity occurring here. And we have no substantiation or corroboration of that that's what's going on.
Question on 14, 15, 16, 17, and 18. This respondent stating that he never got the notice to renew his license.
They stated that it went to an old address. They've never said they never received it, because what I understood was that the mail was being forwarded to their new location. However, there was a delay in renewing, and that was where the problem was. And also, I have to add one more complaint that was not included in this group. When we go through the legal report, I'll add it, but it's the exact same allegation as the other 4. So just to clarify, there's actually 5 complaints that were filed that this was an out-of-state collection agency that is engaged in collection activity on an expired license.
But they are licensed now, and their license is in good order, apparently, according to 12/31/18.
Yes, sir.
Okay. I think a letter of warning would be appropriate if the board agrees.
Yes.
Number 19, in the middle of the paragraph, the complainant also states that the company is backdating letters to make it appear the respondent is in compliance with the law. However, the postmark on the envelope shows noncompliance with the law. Did you see any of that?
No, sir, and I believe that's just the allegation. There was nothing to show that that was in fact occurring. It seems there might be some lag between the mail being actually drafted and signed and then processed to go out.
But that'll happen, for sure.
Right.
But if they had some proof that that's what they were backdating letters in order to
Covered them.
Number 8, unlicensed activity again. I think a letter of warning would be appropriate.
Okay, I can do that.
Hey, if there are no other questions or comments on the legal report, I'd entertain a motion that we accept the legal report with the changes made and the additional answer. Is that a correct motion?
Yes, sir. If you would just allow me to read the additional complaint that was excluded from that group of 4, 15, 16, 17, and 18. The additional complaint is complaint number 20178821.
That it?
Yes, sir.
Okay. Is there a motion to accept the legal report as written with changes made? Yes.
Second.
Moved and seconded. All in favor say aye.
Aye.
Okay.
We have an additional matter that we're going to discuss that we were going to do now instead of during new business. Definitely need to be here for this discussion.
Okay.
About 2 days ago, is that correct? 2 days ago it came out? About 2 days ago, a Supreme Court case came out, U.S. Supreme Court case came out discussing whether or not the Federal Debt Collection Services Act was going to apply to debt collectors who purchase debt before collecting on it. Basically says that no, it does not. That those people own that debt, and therefore they are not considered debt collectors for purposes of the federal act. I have copies of the Supreme Court case for all of you, and then I have a Tennessee Attorney General opinion from 1999.
We already have the copies of the case. We don't have the
Oh, sorry. I didn't realize that you had been given copies. Basically, the Tennessee Attorney General opinion, I guess this question has come up before with the Tennessee legislature.
I don't have the Attorney General opinion. Thank you.
And the Tennessee Attorney General just held that the language of the TCA clearly intends to include those people who or businesses who purchase debt before collecting on it. So basically what that means is our act, the Tennessee Act, definitely applies to those people as far as licensure goes, but we cannot apply the federal act to those people. And as I'm sure you guys are aware, a lot of the violations that the disciplinary council in their legal report come from the Federal Debt Collection Act. Or am I saying that right? I think Fair Debt Collection Practices Act. I'm sorry. So we wanted to make sure that that was brought to your attention and we had a chance to discuss that.
So Tennessee does not require anyone who purchases debt but does not attempt to collect the debt to be licensed. If you purchase and you make an attempt to collect the debt, then you're a debt collector for Tennessee.
Yes.
Now, someone who purchases the debt does not attempt to collect it and places it with a law firm, for example, for collection. Is that debt subject to the FDCPA? So the law firm would not be under the FDCPA, and as long as the buyer does not make the phone call, then they're not under our rules.
Correct. May I add? So just to give a little bit more clarification, under our statutes and our definition, that would be TCA 62-20-1023, we specifically include purchasers of debt as third-party debt collectors, and we require those people to be licensed. So in the industry, as I understand it, you have people, debt collectors, where, or as we call them, collection service agencies, where debt is placed with them for collection and they receive some sort of profit arrangement. And then you have other collection services who are actually purchasing those debts. And there's
not collection services. They're debt purchasing companies unless they attempt to collect it. If they only buy, okay, I talked about this a year or so ago. Banks buy debt all the time. And I was very frustrated that a bank who buys debt and attempts to collect on it is not required to be licensed by us, because banks make phone calls to collect debts they've purchased when they buy another bank. Now, to me, that's a slam dunk.
That's a slightly separate issue because those are, they're banks and those are exempt from our licensing requirements. I'm talking about...
Bank is exempt like a lawyer is, specifically?
Yes. So I'm talking about private companies who are purchasing those debts. They don't have to be licensed under Tennessee law, so I'm talking about Tennessee law right now. They don't have to be licensed if they have a licensed collection services company or a law firm collecting those debts on their behalf. But if they are personally collecting those debts, they have to be licensed. Here's what the Supreme Court opinion does. It differentiates between what we consider both third-party debt collection in Tennessee, companies that have accounts placed with them for collection on the creditor's behalf, to collect those debts on the creditor's behalf. The Fair Debt Collections Practices Act applies to them. Companies that purchase those debts no longer have to abide by the Fair Debt Collections Practices Act.
So if a company, an LLC or a corporation buys a debt, it does have to be licensed.
That's
in
correct.
Tennessee.
Right.
Violations of the if they don't send out a validation federal requirement, then they're not in violation of any of our.
That's incorrect because under 62-20-115B5, violations of federal law are considered violations of our statutes.
Supreme Court exempts them from federal law.
Oh, right. Okay. Yes, I see what you're saying. Yes.
So if a debt collector, a debt buyer, decided to become licensed and they collected the debt themselves, they would not have to send out an initial notice.
Right. Correct. If
So the only violation that they could do the only state violation they could do would be acting as an unlicensed.
If in fact they were unlicensed, right?
But they can go out, well, okay, if they're licensed, they can go out and break somebody's leg, or they can report the bad debt to all the neighbors and friends and put it in a newspaper and what have you, but they haven't violated any of our laws.
They haven't violated any of the FDCPA laws.
What have they violated any of our laws? License, they got a license, but they do all these horrendous things to collect the debt.
Well, we defer to the FDCPA in those situations.
But since it doesn't apply,
Correct.
we defer to zero. and
Correct.
therefore we have no
Unless
grounds to-
there were some rules or regulations.
Trust money or something like that. Well, it wouldn't be trust money either. But
We can only apply what is written in our rules and statutes.
So if the debt buyer got licensed and called the wife and said your husband owes it, or called somebody at the house and says your husband owes it, you need to pay it, they haven't violated our rules, because the FDCPA says you can't disclose a debt to another person. You can only deal with that party.
That's not something that we have specifically in our rules, and we've just referred to the act. Then no, there's nothing.
But we really can't even bring them under the federal act because they're exempt by federal law, and we have to follow federal law, I believe.
Yes.
So there are options for what we could do with this. I mean, we could do rulemaking here, wanted something to discuss.
But would our rules apply? Well, if we had separate rules of our own, that if we had a rule that sounded just like the FDCPA and adopted that rule, then that could apply.
So could we make a rule that says any licensed agency must comply with the Fair Debt Collection Practices Act?
I mean, if we cited directly to the Fair Debt Collections Practices Act, then these third-party buyers would still be exempt.
We take the specific things that the FDCPA
Incorporate
require
them,
and just
right.
make our own rules like that.
Right.
We'd have to pass our own FDCPA.
Yeah, I think that's what you're going to be finding states do. They're going to file their own. They're going to call it the Tennessee Fair.
So, in response to this, if you want, in response to this, we can start working on rules where we go through the types of violations, because you still have rulemaking authority over people that the statute allows you to license, and our statute does specifically require these people to be licensed. Yes. So we can still start thinking about what kind of rules you want to, I think it would be a bad idea to try to refer it all to the federal, because I mean it's been made pretty clear that the Supreme Court says this doesn't apply, but that doesn't mean that we can't go through and decide which principles in there we want to incorporate into our own rules.
We couldn't even use case law to support. Federal case law wouldn't support our rules if there's an interpretation. So anybody trying to enforce that, my specific concern here are the mills who go to courts, find someone who's being sued, and file an FDCPA violation. That is moderately rampant, and they go for the $1,000, usually settle $4,500. Those file in state court would be the only way one of those mill companies, mill law firms could. If they file in federal court, they don't have a case because the FDCPA doesn't apply to a debt buyer. But
That
does
is
it apply?
correct.
But does it apply to the debt buyer's law firm?
Yes.
Law firm. Law firms aren't
Oh,
under our law.
Law firms are
Under our law, but
exempt.
they are under the Fair Debt Collection Practices Act.
They are.
If
they
they're
didn't
acting
buy
as a
from
collection, if they're acting as a collector for the debt buyer, they have to comply with the act.
Unless a law firm buys the debt.
The law firm
Bingo.
buys the debt and they
If you're a
collect
law
it.
firm and you buy the debt, boom,
Dan, you want?
yeah.
You're not licensed in Tennessee or
I'm
anywhere
gonna
else?
say that that sounds correct, but I would want a chance to like double check my sources before I confirm that.
If a law firm bought the debt, now, does the, well, they'd be subject to their Board of Complaints.
Board of Professional
Yeah,
Responsibility.
well, yeah. But it doesn't say at what level the debts are purchased, because, okay, there's first, seconds, thirds, quads that you can buy that have been sold and resold. Debt is resold. For example, if a debt buyer sold their entire portfolio to a law firm, poof, the law firm's exempt. Bona fide sale. They just took deferred payment terms. Sorry.
We can't write rules for a law firm. We know that. But if they apply for a license, then they're going to have to comply with our rules. But they collection agency license. I think we should begin the process of writing rules that we could set for our debt buyer / collector. We can't, the buyer, if the buyer hires a licensed law firm or a licensed agency, then they're already under the purview of debt buyer. I think we should process. Is this going to require some legislative action, or can we do it by rule?
We can probably do a fair amount of this by rules through the board's rulemaking authority. So from what I understand, this board hasn't done a ton of rulemaking in the past, if only because you were able to refer, to the federal act so much. But basically, just as a primer, rulemaking allows you to interpret your statutes, but you cannot exceed the authority of your statute. So that's how it goes. So here, we're just going to have to go through and see what part of your statutes, what the parameters are for your rulemaking authority. But generally, most of the things in the Fair Debt Collection Act, I'm going to assume would fall within your rulemaking authority. Maybe not all of them, but probably the majority.
That's what we can write some rules that will.
It says you can't be bad.
I'm sure board members, you are well aware of this, but just as a little bit of history, I don't think Congress anticipated this type of debt buying occurring at this level when the FDCPA was enacted. So that might be the rub why this opinion, says that they are exempt. So it's a new day basically for this type of industry, that these large corporations are buying debt and then collecting on it.
Opinion hits on what Shalina just said at the very end. The fact that they imagine that this may cause the legislature to reconsider how they are defining collection, but that's an unknown. I will say that if you were asking what your rulemaking authority is, I can tell you it's 6220-104. G says the board shall promulgate rules relating to the general conduct of collection service business that are consistent with recognized business practice in this chapter. So that does give you fairly broad authority.
Okay, thank you.
Would you like me to start
Yes,
drafting
ma'am.
rules?
Yes, ma'am.
Okay.
Application review.
Yes, sir. If I may, let me give you some updated documents right quick.
Thank you.
What you have here before you on the iPad specifically is American Credit Acceptance's response to the two questions that the board posed on the last presentation. One was they marked yes on the question, had any civil actions regarding financial transactions pending. As a result, the board wanted more information regarding that lawsuit that was filed against the company in Tennessee and requested the amount held in trust for clients. And so what you have before you as well in your handout is the difference between their original application and then what they revised it with explanation. So on top would be the original application. Underneath it, the handout that I provided is their edited application with their explanation. So that would satisfy, or at least that's their response to the second question. And on the iPad is their response to the first question about civil actions. And in essence, what happens is they filed for a summary judgment, and right now there's no record of response from Simpson, which is the only one that's been reported. The case is Patricia Simpson versus the ACA. It's a single plaintiff lawsuit by consumer alleging wrongful repossession, and then of course they give their response in several documents.
I'm not sure where our statute lies in wrongful repossession. Talking about a repo service, and I don't know about this particular case, but a repo service goes out and repossesses Steve's car because he didn't make the payment. He, in my opinion, at least doesn't need to be licensed by our board. Yes, he goes out and says, "You either pay me $500 or I'm going to repossess your car." Now he's acting.
I think the issue is that these people applied for a license and they had all these cases that they disclosed to us, and one of them was in Blount County, and we wanted to know about the case.
That's right.
Yeah, Patricia Simpson, or I think that was Simpson is the person the case had to do with, and from all the responses, I read all those. It sounds like she pretty much hasn't responded, and they've gone through all the proper legal hoops to. She must be representing herself, is my guess. I don't know that. Is that correct, or do you know?
She was listed as the plaintiff. I don't know if she's since received representation, but initially she was the sole listing as the plaintiff.
She went to the court, complained, they gave full responses, and then apparently she's not responded back at all from their responses to the court.
At least we don't have record of that, no,
Yeah.
sir.
So, generally, if the court dismisses it, I don't see where we'd have a problem. Do we know if the court's dismissed the case?
No, sir. It was left at just no response, and it was a couple months in with still no response. So it was filed the end of February and the beginning of April. No response up to that point.
They also actually filed something saying you haven't responded, so we need to drop it. Someone else filed you got to drop it because you hadn't responded, and there was no response to that. The only thing, the case that we asked for after we saw it, it doesn't bother me because they did all the right things in terms of the case. But I'm just curious. The trust account is in thousands. We'll just 5,464, and the accounts due to clients 17,356. Am I saying they're telling us they don't have enough assets to cover accounts due to clients? That's on page 6 of the handout you gave us.
There's two handouts, and the first one on top was the initial application, which was the reason for pause and for concern, as stated.
Account 0.
Yes, sir. And then the second one is their revision in response to that. Apparently, they didn't quite understand that question, and so they made an explanation on that as well, and on that application, explaining that they don't have any clients at this time. So they've made the adjustment or edit for 0 in trust account and then 0 due to clients as well.
They don't have any clients, but they've got a bunch of lawsuits against them.
They're in first-party debt collection.
Okay.
Apparently, they're collecting their own debt if they're first party, or they're a debt buyer. Just kidding.
My question is why did they ever tell us they had money in a trust account if they didn't?
Are they a loan company? Their name would accept
Yeah,
us.
I think what they do is they buy. They're like GE. You go buy a car and they buy the debt from before it's delinquent. They buy it.
So it's their debt.
It's their debt.
Yeah, in fact, it said somewhere in the document that they owned it before the first payment was made.
Correct.
So it was, so they buy fresh debt, just like a mortgage servicer that takes it over and owns it, and so it's good. So basically, they're collecting their own paper. We don't.
Their application's on page 28. I apologize. Just wanted to direct your attention to that as well. The full application. Pages, if you go to 28 on the iPad at that particular application, that's the original application. And then page 31 through 33, it was a protected PDF, so it didn't take, hence your handouts in your hand now. But the rest of the application is there for your purview as well. 28, sir. Yes, sir.
The revised balance sheet information that they sent in with the 0 balance, done by a CPA also?
It's done by their senior manager accountant. That's right. Yes, sir.
I don't know that we can make a federal case out of this, but the original statement says that they had a trust account and they owed clients they had $5,400 in a trust account and they owed clients $17,000. Now mysteriously they don't have any money in a trust account and they don't owe anybody.
List of collection licenses held. They have licenses in a bunch of other states as 331.17, but they don't have a license in Tennessee, apparently. They gave us a list of states they're already licensed in. Were they giving us the trust account for the other states where the rules might be different and don't affect us? We don't know.
No,
It's all speculation.
mhm.
Held it back was because of the out of trust appearance, and because we wanted to know more about all the cases they had. All the cases they had seems to be explained reasonably,
Yeah, I'm okay with
and so that part's okay. But the revised, who signed off, or as Bart said,
accountant,
did a CPA send us this revised statement? If the CPA works for them, it's fine. All they have to do is be a CPA according to our rules, or a PA.
It was issued from their accounting department, and their senior managing accountant. Now I don't know if she was a CPA, but she was the one that was in correspondence with Miss Youssef that provided the documents that you have before you now.
Would it be fair to ask them to give us an explanation as to why all of a sudden do they not have a trust account when their first application said they did, and now they don't owe any clients, but their first application said they did?
Bart, their first application also told us they have licenses in other states. This application, I'm just guessing, says they don't have any clients. Are they just talking about in Tennessee?
Tennessee, yes, for this application.
So
That's
they
what they're
obviously
talking
have other clients, other places,
Right.
because they've got this list of agencies.
Yeah.
So were they giving us company-wide, or did they just revise this to just Tennessee, which is all that we really care about?
That seems to be the gist. Obviously, that would be speculation, as stated. But from talking with Amon, who isn't here right now, they mentioned that there was a misunderstanding in that, and then based on the application in Tennessee, that they would revise that to 0. But I could also, we can send it back and then get clarifying questions if we need to. That would be fine.
Testing, if they don't have clients in Tennessee, it makes sense. I'm not saying they don't have clients anyplace else.
And they gave us a Tennessee Collection Service license application business plan where they talk about their employees in other states and how they want to expand into Tennessee once they get their license. So that makes sense that they revised it to only be Tennessee.
They're large enough to have that size accounting department. I'm going to be pretty sad.
And the balance sheet is one page of the balance sheet is actually signed by their corporate controller, Stephen Brooks Barnett.
Yes, there it is at the top.
I don't know.
Certified.
Typically during the
True, to the best
process,
of my knowledge.
when we kick it up to the financial approvers, if it's not done by a CPA, I'll kick it back and request CPA prepared stuff.
Okay.
So if it needs an explanation, the financial approver will put that note and I'll send it back. We'll go back and forth until we get what we need to process it through.
So it probably is a CPA that's done all of these things.
Most of the controllers I've seen half and half. Sometimes they're CPA, sometimes they're not.
Okay.
So, but we can always verify on the website.
I keep going back to this zero on the second application. I know it's Tennessee. I know that this is for just Tennessee. But if they were out of trust in other states, do we want to?
We don't govern the other states' trust
I
accounts.
understand, but they're out of trust.
If that is in fact what they understood what we asked for correctly. Because what if they're gross pay? Okay, that's a whole different ballgame. So, and it sounds like they're large enough that they have more than one bookkeeper on staff. And
Excuse me. I just quickly did a search to check if this person is licensed. Mr. Barnett, he is licensed as a CPA in South Carolina, and he is active.
Okay. All in favor of approving the application for the American Creditors?
American Credit Acceptance LLC. Aye.
No. Motion carries.
Next item, of course, new business, is the proposed meeting dates. We should have those in front of us, one of our favorite topics. We just want to cover, I guess, the meeting dates for next year. And were there any amendments that you would like to make?
I'd like to make a suggestion. We move February to the 7th of February instead of the 14th.
Second.
All in favor of moving February 14th to February 17th, February 7th, say aye.
Aye.
Aye. Okay, motion carries. My kids could run through this thing like a freight train. New business, that was new business. Any other new business? Welcome back.
Yes.
Thank you. I do have two questions,
Okay.
though.
Thank you.
The first question is, do federal student loan agencies have to have a collection agency license to collect within the state of Tennessee? Or do they fall under the exemption?
They make loans.
Well, they collect on loans through the Department of Education, like Navient and some of those other companies, but they have to have a collection agency to.
So Sally Mae turns these accounts to somebody to do the collection work
Yes.
After they're delinquent or in the beginning.
Once they're delinquent,
I think they'd have to have a license.
have to have a license. Okay.
If they're delinquent. If they're not delinquent, probably not.
And my second question is, do collection agencies who contracts with a debt management company to settle debts with consumers have to have a collection agency license even if they don't contact the consumer themselves?
Can you repeat that?
Do collection agencies who contract a debt management company to settle debts with consumers have to have a collection agency license even if they don't contact the consumers themselves? So they're trying to, I guess, make deals with debt management companies to settle on debts owed, but they want to know if they have to have a license in Tennessee to collect money from consumers that the debt management company contacts.
Does the debt management company have a?
Well, in this particular case, they said they were out of New York, but I stated I think they would need to have a Tennessee debt management license here to even do business, contractually, even if they themselves don't have to have a license.
Is this the email that you had referred to me? So I have been talking back and forth with that agency trying to figure out exactly what the nature of their business is. And what they have explained to me is that they are working as an agent on behalf of the creditor, negotiating with the debt settlement company, who is an agent on behalf of the debtor, and that they themselves have not, and nor do they intend to ever contact the debtor. Am I saying that? Yeah, the debtor at any point in Tennessee. They're just it's like there's the creditor and the debtor, and then there's two middlemen, and they're one of those middlemen, and they're the creditor's agent. And they have asked me if they need a license.
Doesn't sound like it. It sounds
I
like a
didn't
credit
think so
repair. It sounds like a credit repair company.
Yeah.
And the creditor turns the account over to a collection agency. And then this credit repair company tries to negotiate a lesser amount for the consumer. I don't think they need.
That was generally
I
the
agree.
consensus I had come to, but I hadn't answered them.
Kind of a weird setup, but I
Yeah.
don't think they have to have a license here.
There was one area of new business that was brought to my attention, and if you go to number 7 on the in your library there, it's the 2017 NACARA conference.
Yes.
And I corresponded with their conference director there, and just because they don't have an agenda yet listed, and but they did respond with what some of the items that they were going to cover. So if you wanted to take a look at that, it's in that second paragraph there. It's going to be in Bellevue, Washington, And the dates for that, it looks like it's October the 2nd through October the 4th, and right behind it is the registration form. So there's 2 pages there.
Are you familiar with this organization? It's the National Association of Collection Agency Regulatory Authorities. NACAR.
Yeah.
And I've been to several of their meetings back before when the administration let us go, and they're very informative. And now that we have a new Supreme Court justice that's sending out things like this, I think that somebody should go to see what they say. They always have good speakers. They have collection lawyers. They have consumer lawyers, and it's a well attended meeting. But last year the administration didn't want to spend the money to do it. So I guess what we need to do is ask the administration what their feelings are on this meeting, and then people before, and we've sent one person before.
I think if you all are inclined and it's a productive meeting, we definitely should go ahead and vote on one of the 3 of you at least attending, and then make a decision if attorneys or Glenn, maybe possibly one more person, but definitely a board member going, getting everything you can and then bringing it back. So if you can decide a motion who would attend representing the board, then we will proceed and try to finalize who else would go, if anyone.
I'd go, yes, I would go.
That's fine.
Okay. All right. I entertain a motion that one board member go, and I don't think it.
I'd move that we ask the chairman to represent the board.
Second.
There's been a motion that the chairman represent the board at the CAR meeting. All in favor of that motion, say aye.
Aye.
If there's no other business to come before the board, I'll entertain a motion that we adjourn.
So moved.
Second.
All right.
Good today. I'm going to leave all these here. Is that okay?